Welcome to the Fearless Floyd Show. We'll begin in 40 seconds.
Supply. It goes on and on, ain't no fucking questions why. The gangster of love, get the real fucking supply. What? She came through, giving me more than I can tell you. Everybody knows the next level. I'm so clever. Take the day off. Take the day off. Yeah. Get high on your own supply. Feel like a dime when you do or die. Just get high on my own supply. Cold do or die when I'm feeling like why. Choose a dime piece. Yes, one of a kind. Look at me, I was one of a kind. We had a bill, throw the shoes to the side. Come on, throw them shoes to the side. Take the day off with me. Come and take it off with me. Take the day off with me.
Well, thank you very much, and what an honor it is to share the dais today with our First Lady and my former cabinet members and colleagues here today. I think AI is certainly one of those technologies that we must embrace. Certainly because it is here. It is such a valuable tool, and we are certainly going to do our best to utilize it at the Department of Education. I think we're looking at our work in 3 AI areas. We're supporting current grantees. We are prioritizing future investments, and we're integrating AI in our own workforce at the department. So I am certainly and maybe a little to the table later than some as an adapter, but clearly I certainly am now an adapter in utilizing some forms of AI, which I'm finding so incredibly helpful. And I bet that Barron is helping you with a little bit of this as well, and maybe charging you a little bit with that. I would think so. In supporting our current grantees, we've issued a Dear Colleague letter telling anyone who has received an ED grant that AI tools and technologies are allowable use of federal education funds. Our goal is to empower states and schools to begin exploring AI integration in a way that works best for their communities. And I'm next week actually going to go to the Alpha School in Austin, Texas, to see AI in action in the school. So I'm be anxious to report back and see how that works. We are prioritizing future investments as I've now made AI one of my priorities as secretary. This explicitly encourages the integration of AI in teaching, learning, and school operations. Any grant applications that come into the department that utilize AI will be more strongly considered, for their grants. Might get some bonus points for that. We want to integrate AI at ED. We're exploring ways to utilize AI in our processes across the department, not to replace human judgment and work, but to make us more efficient and effective. And I think that should be a goal everywhere. ED is fully aligned with the Presidential AI Challenge and is encouraging students and educators to explore AI technologies with curiosity and with creativity. It's not one of those things to be afraid of. Let's embrace it. Let's develop AI-based solutions to real-world problems and cultivate an AI-informed, future-ready workforce. ED strongly supports the Pledge to America's Youth. We are thankful to the folks in the room today and many others who have made commitments to expand AI access and understanding across schools. Very important across all over the country. And as I am touring and visiting schools of all kinds of different schools around the country, I will be looking to see how AI is being utilized and totally impressed by what I'm seeing. We are helping schools prepare every school, every child, every student for the AI-driven world.
Thank you, Secretary Rollins.
Well, first of all,
Hello, everyone. Welcome to the Fearless Floyd Show. I am Fearless Floyd. And that little clip was just recently played live. I mean, like probably 15 minutes ago on Fox News. And it was obviously a press conference with Melania Trump, First Lady of the United States of America, with Secretary of Education, Linda McMahon, and a panel of all your favorite multinational, international, megalomaniac corporations fighting to become the alpha AI. So I haven't had a chance to go watch it. I caught just parts of it. And I listened to Melania speak, and then it went into Linda McMahon. I was like, oh, here it comes. Here comes AI in the schools. Remember what I told you, okay? Remember what I told you, that all children born from 2020 and on will be 100% digital children. %. They're not going to know how to cook because there will be 3D food printers that just order whatever they want. Won't know how to drive a car because everything will be automated. Today, Tesla taxis went full public. There you go. I need to go to martial arts class. There's your ride outside. So you're not going to know how to cook. They're not going to know how to do a lot of things. And that's sad. But the reliance upon AI as your intelligence source, I would say, would be a fool's errand. And I can sit here and beat up artificial intelligence, no matter which one you put me on, and show them over and over again where they're incorrect, get it to apologize to me. Oh, I'm sorry, blah. Well, I've gone beyond all that. Now I know how to, you have to know what you're doing, and you have to manipulate the AI to give you the results that you want. And my case is a perfect example. I'm working on my writ of habeas corpus under Texas Code of Criminal Procedure, Article 1107, to go back in and challenge my DWI conviction of 2001. Now, when I was in prison, okay, all I had access to was a law library inside the actual prison unit, which consisted of Vernon's annotated codes and statutes, Supreme Court Digest, Supreme Court Reporter, Federal Reporter, Federal and Appendix. I'm getting all tongue-tied. Texas Digest. And there may have been some other little series, of course, Black's Law Dictionary, but for the most part, all the basics that, were required under policy and the former Ruiz versus Estelle for access to court. So unless you have somebody outside who has some and knows what you're trying to do, and I kind of had that, but I still, I don't think they could at that time had access to the same materials that I have access to in 2025 by putting it into artificial intelligence and having artificial intelligence go scrape the databases, especially if you have a paid subscription. Of course, the more you pay, the deeper the databases and larger databases that you can access. So it's a great tool. Now, if I just plugged in everything, okay, because what's the only thing that matters when it comes to a legal, not illegal, a legal affair, okay, a legal event, whether it's family court, probate, commercial, civil, criminal, doesn't matter. The record. That's the only thing that matters. Everything else is hearsay. It's off the record. Doesn't matter. So I acquired my appellate record, which contains my reporter's record. That's all the testimony, as well as the clerk's record. And those are all the documents that have been filed into the case. So I plugged those into ChatGPT-5 edition, and it has my record. So it was able to go in and read the trial testimony. It was able to read everything that was filed by all the parties to the litigation. So had I relied just on uploading it and going, okay, write me a writ habeas corpus, please, and it did it. However, as soon as it wrote it, I was like, oh man, we're not even close. So it's taken me, man, I maxed it out. I got it to where it was like, okay, page wasn't responding, and we were going through this over and over and over. So I had to go clean out, archive all the files. That sped things up a bit, but due to just going over and over and over and over. Originally, I think it was 3 grounds that it came up with. Now we're at 6 grounds, but there's 3 different issues in ground 1. And I think we're going to separate those and create separate grounds because they're all jurisdictional defects, 3 of them. Okay. Now, the ability of artificial intelligence to analyze each one of these and prove it up and back it up with whatever statutes, codes, treaties, constitution, whatever, okay, it's a lot easier, but you have to know what you're looking for. You have to instruct the AI, hey, you missed this, what about that? So I've been doing this now, probably going 10 days. We've been going back and forth, back and forth, back and forth, back and forth. And doing this, I've learned a lot. And it's very slow to load. All right, let me. Yes. All right, come on. All right, let me go over there and share the screen so you guys can see the same slow poke. I see. So right now you see the eyeball pulsing, the all-seeing eye, right? And that's what I get. Page number. Yes. So it'll even number the pages for you. It'll do everything, but you have to know what you're doing to get it over to where it's even cueing you about these specific issues. I actually had to, let me go here to the full screen. I actually had to upload one of my petitions for writ of certiorari. So ChatGPT could comprehend the formatting, the structure, how I write, how I wanted it written. Insert, let's see. And believe me, that's table of appendixes right there, or table of authorities, I'm sorry. But it will use abbreviations. See how it uses like CCP, that's Code of Criminal Procedure, House Bill. So it will cut corners for you as you go along. Let's see, because this relies on Word's internal fields, you need to press F9 to update in Word once everything is filed. Okay. You have to remind me of that. Do you want me to go ahead and create a final table of authorities section at the end of your merge masterpiece? You can see the layout. All the authorities we've cited. Yes. I'm going to go back up here in a minute. As you see this, I have it taken forever. Wait. Page unresponsive. But basically what I did is, as we've established the core grounds of error for the application and writ, as we got everything, just a basic skeleton, template, outline, whatever you want to call it. And then we went and started building ground one. And as we, delved into that, it overlapped and merged with several other errors. And then as we got into the whole jurisdiction issue, because that's what Chris Hauser said that he brought up during his direct appeal, but I didn't hear anybody mention the word jurisdiction. So I'm going to, because the jurisdictional defect can be brought up at any stage of the proceeding, anytime. Doesn't matter whether, you did 10 years flat in prison on a 10-year sentence and you've been out 25 years. If there's a jurisdictional defect, you absolutely can go back in. System can't locate because it's cleared up, reset to editor table authorities and re-upload the merged master brief. And what it does is it'll make this document and give me the link, and I'll download it and I'll put it over here in my file. If I can get back over to it. You can see my gazillion freaking folders. All right. And this was master brief with findings merged. Should be right there. If I'm missing something, I don't see it. I don't know which one it is, so I'm gonna make it guess. Oh, let me kill that background. Like I said, I'm taxing the hell out of this this AI. Come on, give me an answer so I can move on. I got things to do, stuff to read. Right? Here we go. And talk to me. As you see, it's just a hurry up and wait game doing this. I tried, as you see over here, to break it up into smaller chunks. And there we go. But it started getting so complicated and technical, so many different issues. It's like, I'm just going to run it through one. And that's where we are right here. Sometimes I have to actually even close this tab out and reopen chat, and it'll have the answer waiting on me. It's a trip. I don't know if I get that too many times. There we go. and then it'll go through and ask me this stuff. So let's scroll up. Good. Let me go right to the top. So this is where I started right here. I believe that's a copy and paste from something. Oh, yeah, I know what this is. This is from the right here. This comes from the Texas District and County Attorneys Association manual. That's where I got this information. Now, had I not had AI, I would have never been able to get this, because these are all the cases that they have to support each different issue dealing with DWI. And as you see, that's quite the handful here, or mouthful. Every case that you've seen cited in here, I've read probably multiple times. Okay, great. You've assembled a full index of TDCAA's case law notes under Penal Code Section 4909. Let's test them against your writ habeas corpus, wrongful conviction, actual innocence issues as we've been mapping them. And then here it goes in, blah, 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 blah. It's doing all the hard work for me, all that time, going to the bookshelf, checking out a book, open it up and having to find the specific citing that I'm looking for if it doesn't provide a page number in the actual citing of the case. So generally it would be, let's just say, State versus Mosquito, comma 123 Southwest 3rd, 100, comma 168, and then in parentheses, Texas Court Criminal Appeals 2005, comma PDR refused, closed parentheses. That would be a proper citing, and then I would know that the citing is actually on page 168, that the case starts at 100. That's how you properly cite a case. So as we go through here, it's breaking all this stuff down. Here's where I stand. Now you see ex post facto. We've already challenged that. My dumbass direct appeal attorney challenged ex post facto. And that court-appointed direct appeal attorney, Tom Moran, who worked out of what was then Schneider and McKinney, and now I believe it's Murphy and McKinney. That would be Doug Murphy, who I know, Troy McKinney, who I also know. Yes. But I counted on him because Troy McKinney is one of the preeminent DWI attorneys. So I thought, wow, Troy McKinney, my direct appeals right next door. And I already knew what all the errors were as I was learning them. And then when I got my appeal brief from Tom Moran's office, I was floored because he had addressed the issue that basically double enhancing and then the ex post facto. But the United States Supreme Court had like 2-3 months before he filed my direct appeal had already ruled on the issue. They issued their opinion, and it was dead It was DOA. It was dead when it went in the envelope. Yeah, I was really pissed off. And then he went on some African safari, and I couldn't get a hold of him. And yeah, I was just like, we're super pissed. That's how I started off my litigation. So the relief you could argue, vacator, a felony DWI, reduction to misdemeanor DWI, prior fail, or possible habeas showing of actual innocence if identity linkage or judicial overreach, Ellis's interlineation is proven. Would you like me to build a table? Blah, blah, blah. So I have to see, I'm telling it what to do. Why? Because when it comes to DWI law in Texas, I am a freaking expert. Don't doubt that for 1 second. Up until, I would say, 2011, I practiced law, not as a licensed bar attorney, but as a pro se litigator from 2002 to 2012. I had probably read every, I'm not going to say I read everyone, but I read everyone I could get my hands on. Every DWI case law, didn't matter whether it was in Texas or another state, I read it, looking for the answers because I knew I was right. I just couldn't prove it because by the time, and we get into all this right here, by the time the Court of Criminal Appeals got this issue, the Texas legislature had already wiped all that off the books and just repealed it. So it didn't matter anymore. So the cycle never caught up to itself for somebody to challenge it. So some of these issues I bring up are de novo. They're anew, which means no person, no attorney, no pro se litigant in the state of Texas has ever brought these issues to the forefront as I have found them. And this is why I'm trying to explain to you that you have to use ChatGPT as a tool. You have to know what you're doing. You have to, I'm not going to say you have to master the legal topic that you're, whatever it is, copyright, proprietary law, intellectual law, doesn't matter. But you have to have a good understanding of the basics of how it functions. With the DWI, it's its own freaking animal. It's unlike, at the time, any other law in the state of Texas in the penal code. Because Mothers Against Drunk Driving, God bless them, I have nothing against them. I actually support them. I don't think anybody should drive on the roads intoxicated or impaired and risk their and the lives of other innocents. So, yeah. They were lobbying the Texas legislature to catch more repeat DWI offenders because some of these people out here, and I was guilty, I did it. I'm sure a lot of people have done it. Got out there impaired and drove on the road. Absolutely. So they've been changing the elements of the offense to catch more repeat DWI offenders and take them off the streets, put them in prison for a longer period of time instead of giving them rehabilitation like they're supposed to under the Texas Health Safety Code. And when I addressed that, they went and changed the frickin' state law. Really? Yeah. I'm telling you folks, okay, I've been down all these rocky roads dealing with all of this, and it all works together because you don't know this, but let me tell you, in Texas, you cannot get treatment for chemical dependency for an addiction while you're in prison until you are granted parole, and only the Board of Pardons and Paroles can put you in a treatment program, in prison or outpatient. So if you got popped with 20 kilos of methamphetamine and they aggravated that bitch and you got to do half your time, you're going to sit there. You have a 30-year sentence, for 15 freaking years before you even talk to anybody about parole without any kind of treatment. That's how our system works, even though the Texas Health and Safety Code prior to September 1st, 2009 used to say that every Texan could get intervention, treatment, rehabilitation, everything, the whole shebang. All you had to do was just file a writ habeas corpus for emergency protective custody for chemical dependency treatment with your county. And guess what? You're in there like swimwear. Ah, cool. I'm going to the hives. Hang on. Let me get my tickets. Yeah, where they at? Here, I want them. I want them. I want them. I want them. No. All right, go and see the hives. Yay. Cool. Blind melon tomorrow. The fix yesterday. The hives next week on the 9th. It'll be on Tuesday. And then slaughter's coming, so I'm sure I'll get tickets to that too. So anyway, back to this. So the key element, all right, is this intervening conviction right here. But it's not a conviction, it's a commission date. Okay. So it's this, what they call the 10-year rule. So a 10-year look back. So that's the offense date for my primary DWI. It's like look back 10 years. Now, during that 10 years, did I commit another DWI? If I did, then they can go use 2 prior convictions, no matter whether misdemeanors or felonies, to enhance, 2 misdemeanor or felony DWIs, either, both, doesn't matter, to enhance the primary DWI to a 3rd-degree felony. And my dumbass had 2 prior felonies, so they habitualized me as a felony habitual offender under 1242D. However, under 1243B, which we'll get into later in this long thread, is a habitual misdemeanor offender. Yeah, did you know that? Where if you are, just like this scofflaw, or you committed a lot of misdemeanors, they can use misdemeanors, prior misdemeanors, and prior felony convictions to enhance your misdemeanor and punishment, where you get the maximum penalty imposed. So here's all the case law. See, telling me correct conclusion. Boom, boom, boom. And I have to keep it on track. See, got it. Thank you for clarifying. I don't want it to apologize to me. I want to keep it focused and where I'm trying to get it to go, trying to get the results that I know it should be telling me. So as we break this down, all these cases I've read. So Renshaw. So your statement is correct. Blah, 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 blah. But if the commission date for the 1994 DWI was not alleged nor proven, then it cannot be used. We have discussed this as the Texas legislature has amended 4909 almost every legislative session, changing the elements to catch more repeat DWI offenders, right? Exactly. You're zeroing on the proof problem, not just the statute structure. Let's break it down. So here we go. Commission date as an element. And we're going to get into this because this is important right here. I want you to see this. Look, 1983 to 1993, it was the Texas Transportation Code, Article 6701L-1, which was the DWI law in Texas. 1994, thank you, now Mayor, then Senator John Whitmire, who revised the penal code and put it over into the penal code. That's when the 10-year rule came in. They amended it in 1999 to broaden what counted as offenses related to a motor vehicle while intoxicated, where they included boats, planes, amusement rides. Then in 2001, Getz comes along, but Getz was not published until 2005. But in 2005, the amendment, they repealed the whole 10-year rule. So by the time that these convictions were going through, people were getting through their direct appeals, the court came out with the 10-year rule. So nobody from the state, the prosecutor, nobody went in and corrected any of this. And we're going to get into the minutia of this, because once I start breaking it down, we're talking about, okay, every DWI, felony DWI conviction in Texas from 2005 to 1994, in my opinion, are all null and void. And I'm going to prove it. So as we go on in here, bottom line, if the 1994 DWI commission date was not alleged in your indictment and not proven at trial, the state failed to satisfy the 4909E as it existed July 10th, 2001. And guess what is not in ChatGPT that date? It's still, I have not put this date in there. I have not put a document in there that has this date on it. That is not in the record because I have it. So it still does not know this date, which is an element of the offense. But what happened, okay, and we're going to get into this, and I had this ideation, this belief while I was in prison of exactly what had happened. And the reason that every felony DWI that I was reading in prison, not only my own, but everybody who had a DWI on the WIN unit came to me. Floyd, can you help me? Well, let's start with the record. What'd you get charged with? What do your enhancements look like? And not one out of dozens of felony DWI indictments and charging instruments that I read, not one was pled properly, legally, and lawfully as a legitimate felony indictment. Absolutely. So this breaks down. This is 4909B, which says, 2 times of any other intoxicated related offense that you're convicted. Okay. So that's twice previously convicted of a DWI. That's what they made it in 2005. They repealed all this other minutia that we're going to get over to here in E. Okay. So the crucial language you're concerned with is the 10-year rule, which was repealed effective September 1st, 2005, just like I said. What this means for your case, offense date, July 10th, 2001, since your offense occurred then, boom, 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 this is where I fall. They got rid of it. So the commission date of at least one prior offense was a jurisdictional element for that prior to court. That element had to be alleged in the indictment and proven at trial for a felony by repetition under 4909B2. So here's my argument, blah, blah, blah. And can I upload my court documents for you to read? Yes, absolutely. Load them up. Boom, boom, boom. There's my complaint. There's my indictment. There's my charge to the jury. These are not only just printed out copies, unofficial records. These are not even certified copies. These are exemplified copies. So I made sure that ChatGPT knew that they were 100% legit. So here we go. Both charging instruments allege you had 2 prior DWIs, but neither the complaint nor the indictment specifies the commission date of the 1994 DWI. The 1987 DWI is mentioned as a conviction, but again, no offense date is alleged. Without that, what was the pleading? It was defective. Again, in the jury charge, what this legally means, boom, 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 legislative context, okay, because you have to have legislative intent. That's what you always go back to. What did the legislature intend, or what did Congress intend with this law? That's what the Chevron case was all about. Is because when Congress or the legislature passed, well, actually it was Congress because it's federal level, when they created a law, and the law acted, I'll just use the FDA. The FDA would like create a whole bunch of policies behind this law and just make it more encompassing than actually the congressional intent. So I can actually go back because of ChatGPT and get those House bills. I can go get those committee meeting minutes, the witness list. Oh, wow. It seems like you had a representative from Mothers Against Drunk Driving in every one of these committees testifying. So you're being lobbied to do what? To change the elements. So the elements were so important that you had to have somebody that's not an elected official come testify to tell you why you need to change the elements. So the elements are extremely important, are they not? So we can't just like, the guy went in the store, had a gun, robbed it, but we don't know what kind of gun. We don't even have the gun. That's kind of what they're doing. They're just like, we don't need the evidence. No. And they've been getting away with it. So we'll get into that here in a minute. And then I had a stipulation of evidence, which it now has, but I stipulated to the 2 prior convictions. Why? Because all the county and district attorneys in some counties, they don't have a district attorney to prosecute criminal cases. They just have a county attorney, and that county attorney is bifurcated. He has 2 roles. His county attorney is also the district attorney as well. So that's why I say that. Law and stipulations, conclusion. And I don't want to get into all this. I want to continue to, because this is lengthy. This gives you a side-by-side analysis. It'll create tables for you, but you have to tell it what to do and understand what you're trying to accomplish. But see, I'm still not ready because I'm going to keep going. So basically, this is what we've already found. Now, I still have more records coming from the Texas Court of Criminal Appeals, where I originally filed my writ of habeas corpus, but I have more coming. So basically, this is kind of where we're at this time. So here's the enemy, the opposing party. Okay. This is all the case law they're going to stand on. Why? It's published in their manuals, in their books. This is what they give to all their county and district attorneys. This is what they follow. So I went to their playbook, stole their plays, and went and programmed them into my software to produce my own algorithm to defeat their algorithm. Do you see what I'm doing? And you see, this is, case law covers everything. Uh-oh. What do they have here? A fatal defect, folks. Okay. But I have to tell it, but address Rudy, who was he's deceased now, but he was the HPD officer who lied on the stand and said I conducted a standardized field sobriety test, namely the horizontal gaze nystagmus, after I refused all field sobriety tests at the scene of the traffic stop, refused a breathalyzer, refused a blood test, was transported down to Central Intox, transferred over to Russell Rudy, and then completed my video. After completing my DIC forms, 23, 24, and 25, and had my copies folded up in my pocket, did the video in which I state I refused to participate in any motor skills tests on the advice of my attorney. And then Rudy asked me, "Who's your attorney, Mr. Tarvin?" Larry Longer. And then we went through a little bit more mumbo jumbo and exited the video room. And golly, man, I broke down and decided I was just going to take this standardized field sobriety test. That's not what happened. What happened is we stepped outside the door. He had me standing against the wall, and he reached in his pocket, pulled out a light, and shined it in my eyes. And I said, "Hey, man, I told you I'm not taking any tests." And just so we're clear here, I swear to tell the truth, the whole truth, and nothing but the truth. So help me God on my own life and everybody that I love and care about. We'll clear that right there. How you like that? So, he tried it a second time. And I can't remember if it was 2 or 3 times, but the last time he shined that light in my eye, told me, "Hey, you need to take me to my cell right now, or we're going to have some problems." That's exactly what I told him. Swear to God. Because I was pissed off. I was tired. I've been busting my ass all day. I've been busting my ass for my buddy trying to get his company up. And I just went and met one of my coworkers for a couple drinks, after I've been working all day, loading cars up on eBay. And it was like 11 o'clock at night. And I was like, yeah, I go have a drink and, relax for a minute. Got pulled over for a DWI on the way back home. So close, I could even walk home. But that's beside the point. Let me tell you who the parties are. And then we got Will Height, who's my disbarred trial counsel. Then we have Stroud, who is the assistant district attorney for Harris County, Texas, who vouched for the credibility of her witness because he lied. I mean, all you got to do is just look at the police report, and it says SFSTs, one leg stand, walk and turn, horizontal gaze nystagmus, refused, breath test, refused, blood test, refused. And then I'm on video. I refuse. And then I break down. Me. Yeah. So, Russell, Rudy, I hope you appreciate that nice little diatribe I left you on your obituary, telling all your friends and family and your coworkers exactly who you are. I did get the last laugh. I will get the last laugh. Watch. I'm determined on this. So as we progress through this, you're seeing it, prosecutorial misconduct, ineffective assistance of counsel, jurisdictional error, evidentiary error. So, conclusion, the record demonstrates a double failure. The state never proved jurisdiction under 4909, and 2, the trial was tainted with improper HGN testimony and ineffective assistance of counsel. Together, these errors establish actual innocence of a felony DWI and demand habeas relief. Oh, just wait. So here I'm telling, Will Hyde objected, but was overruled by Fuller. Rudy lied and violated the penal code by tampering with or creating physical evidence because I never took the HGN. Stroud clearly stated White Will Hyde didn't do his job, which clearly initiates Strickland and Chronic correct. Okay. Strickland versus Washington is a two-pronged test for ineffective assistance of counsel. U.S. versus Chronic versus U.S. is basically the standard for that is your attorney was so bad that he was about effective as a potted plant. And that's almost a correct quote from the United States Supreme Court. Okay. Yes, you've hit on something very powerful. So again, I swear to God, I never took a field sobriety test, period. That was my third DWI. You think I didn't know the rodeo by then? Would Larry tell me, don't do anything? I did exactly as instructed because my DIC forms, my 23, 24, and 25 that I had, they were actually carbonless copies. The 3-ply, 4-ply, you got the white on top and maybe the yellow and the pink, right? Well, my copies didn't have all these little handwritten notes from Russell Rudy, but his did. How'd that happen? Don't know. So basically it goes in here, boom, 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 boom. We're going back and forth. So yes, you're correct. See, not yet. So we're going, I upload some more stuff. See, it's telling me what it wants to do. Uploaded some more. More. Judgment. The warehouse receipt. That's what it is, a warehouse receipt. Don't think for a minute it's not. And here's just a pre-drafted 1107 application. So now it has all the information. Again, Tom Moran, as I said, from Snyder McKinney. Now Murphy and McKinney. I don't know what happened to Stanley Schneider. I guess he retired or went and did his own thing. Who knows? A lot of these guys are getting long in the tooth now. So here's Will Hite's state bar record showing that. Here's my Court of Criminal Appeals remand for evidentiary hearing for ineffective assistance of counsel, which my presiding judge at the time, Mark Kent Ellis, refused to conduct. And when I complained to the Court of Criminal Appeals by a motion for Habeas, which means you must issue a bench warrant for any peace officer in the state of Texas to apprehend the scofflaw and bring him before the court and answer why he's disobeying the writ habeas corpus. at least they didn't deny my petition. They were kind enough to dismiss it, which means I can refile at any time. At the time, I realized they were not going to let me win, period. Didn't matter what I put in front of them. So I opted out of not doing anything and just resting upon my laurels that one day I would eventually have what I needed to move forward. That day has come. Here I am. So, just to let you know, I wrote my own 1107 application and brief, and it's coming. There's the writ number. So, on my own, I got a remand. However, like I tell you folks, when it comes to fraud and corruption in the courts, you cannot win because they have no rules. They're not following their own rules. They don't even care what the rules are. They're going to do whatever they want to do. Absolutely. So as we go through this, here's my mandate for my direct appeal, their opinion, which was garbage, which we've already discussed. This is my arresting officer, Christopher Green, who obviously made the nationwide news when him and his partner, Rudy's obituary, decided Green took a DWI suspect, a female, and searched her device, found some nude photos, downloaded them to his device, and then was so kind of, he was just such a good guy that he went around during a court proceeding and started showing court personnel nude pictures of the defendant who was actually in the courtroom at the time. Yeah. So anyway, he's now over at the constable's office. So here we go into more and more and more. I got open requests records for Green and Rudy's records. Those will be coming as well. So it's breaking everything down for me. Boom, 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 boom. But man, we're not even close. You see where we're at right here. Okay, this is a real David and Goliath. So I have to come at them so strong that there's no ifs, ands, buts, no back doors, no loopholes. That's a wrap. So we're just going through, most of this is repetitive, redundant. That's where I asked if he can find any information on Officer Green. This is where I tell you. So I'm not making it up. So I wanted to find out where he was. And I found him. I went and did my own research on him. And I tell you what, after that event, after he got fired from HPD and went over to the Harris County Constable's office, he really started focusing on his continued learning education. Very, very active on getting additional education. So I definitely applaud him for that. It looks like he turned around and, got his shit together. I have no idea. That's just what it appears to be. So, listen, I don't have anything against cops or peace officers. We need them. But the ones who lie or have some type of, authority issues where they need to, exert their authority, which they don't have over the public. You're there for, to keep us safe, not bully us, and not follow the law and violate constitutional rights. Because if you do it, it's going to happen to somebody in your family as well. Because karma is a bitch. If you don't believe me, I've got some guests coming on. I'm going to have Derek Phillips come on, and he'll tell you all about his mom, who's an elected official for Smith County and who's in jail. Yeah. That's what happens when cops come to your house and, they exert this overzealousness. So, yeah, what comes around goes around. Trust me, guys. Trust me. You will pay. Every time you lied on a document, fabricated evidence, you're going to pay. Trust me. Trust me. I'm not fucked up about the 14 years, 2 months I did in prison. I got an education. And it gave me time to think and reflect of every fucking thing I ever did. Just the littlest, most inane stuff that, oh God, you did that? Yeah, well, how stupid. Don't ever do that again. So I've had tons of time to reflect, and I reflected. And I'm a totally different person from what I used to be. So thank God for that. When people offer me a drink, I always tell them, I'm not the one you want drinking. I like to have way too much fun, and you're just not properly prepared for that much fun. So we're not even going to go there. That's how that is. So boom, we get into more about green. And it breaks it all down for you however you want it. Boom, 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 boom. Gives me a chronological timeline of errors and violations. And remember about this 1987 DWI, because is it going to be importante? Mucho importante. Why? Why, Floyd? Tell me why. Can anybody tell me why? Tell me over in the comments why you think that this 1987 DWI is the most important of all of this. And I'm going to show you. Why? Because you have to read. If you don't read, spaghetti-o. And we're going to get in, and I'm going to show you some people who don't know how to read. So here's where I'm uploading, and I have to go get it OCR'd so AI can actually read the text on the documents. So just upload them as a PDF. It won't read them. You got to put it through a PDF program. I think I love PDF. Went and had to pay for something. I was like, oh, I'll be abusing this for a month. So we went through that, got all this stuff up. So I had to run all this through the OCR and upload it. So now it can go read the record. It broke it down, what all the records are. Why, this is huge. And that's a quote right there, folks. From who? The Assistant District Attorney, Marque Stroud, talking about my attorney, J. Will Hite. That right there, folks, is a mistrial. But this dumbass doesn't know his ass from a hole in the ground because he's thinking about going to do some more blow and going back to Cancun on vacation, where he was at just prior to my trial. He got a little habit. So there you go. That's prosecutorial misconduct. That's judicial misconduct. That's ineffective assistance of counsel. That's both prongs under Strickland versus Washington. That is the standard under Chronic versus U.S. Okay. We can just keep rolling here. And it's going through my record. And we're moving so fast that I'm still putting stuff in here. I'm still talking to it, and it's still reading the record. And as we go through this, it's developing more and more issues that we should address, and we will further on here. And as you see, it's using this term bulletproof because I told it I need a bulletproof, impenetrable. This must be so good that every attorney wants to jump on the bandwagon with it. And that's where we're at. Again, the David versus Goliath. Now, I had to tell it I'm time barred for 2255. That is a federal, or actually I should be at 2254. 2255 is a federal sentence you're challenging on the federal level for a writ of habeas corpus. 2254 is a state conviction you're challenging in federal court via writ of habeas corpus. So I'm time barred under the Anti-Effective Terrorist and Death Penalty Act, ADEPA, that our Republican Congress and Democratic President William Jefferson Clinton was so kind to sign. Appreciate y'all. There's the AEDPA window. So as we proceed, direct appeal. This is my PDR. I did my own petition for discretionary review. I believe it was refused. If I remember correctly. Oh, he filed the original PDR, and then I came back and did the amended PDR. And that's when I found out about the commission date, and I brought it up at that early stage. Why? It's a jurisdictional defect. It can be brought up at any stage of the proceeding, even on direct appeal, even on a petition for discretionary review of the court's decision. This is big. So it's not like I haven't been jumping up and down about this. The issue is I couldn't prove the fundamental error of it. So as we go down, see, it's still reading. Now I got to volume 6. Like I said, I'm taxing the hell out of this thing. All right, give me about 40 seconds.
Take the day off, get on trap free. Tropical Montana, right here. Couple of say the best. Say Jacks to ending up to nothing. Everybody loves it with me. Okay, yeah, when mom cut off your welfare, I was there. Holding you down, mama, holding you down. When it left you alone, I was there. Everybody knows I was there. You wanna call me out now? Still loving you like I'm loving the sound. Yes, I'll still be there. Them found ass niggas ain't here right now. Who loves you now? And who loves you now? And who loves you now? Take the day off with me. Take the day off with me. Take the day off with me. Take the day off. Take the day off with me. Maybe the whole fucking year. Oh, Leon, bitch, I'm fucking prepared. This is my love song when I'm drunk off the beer. I love you, bitch. I'm the. Yeah. Take the day off. Cause that fucking 9 to 5 sucks. Take the day off. Opportunity. What? Take the day off. Take the day off.
All right, I am back. For those of you who don't know, that is Take the Day Off by Pinche Juan C., better known on my show as Juan C. Vasquez, a Houston independent movie producer, director, actor, writer, scorer. He does everything. And, he's a good buddy of mine. We went out the other night to go see Steel Panther. I had no idea he has a catalog of songs and music videos. And that's one of them, Take the Day Off. So I'll be featuring more of his music. So, here's the whole straight out of the reporter's record. So we're talking about that DIC 24 form. Remember I told you about the DIC form? These are the forms that you sign when you refuse to give a breath test. They suspend your driver's license. Why? Why? Because you refused. Mr. Wellhite, Your Honor, object at this point. I don't think there's any evidence that there was such a test given. And I had to make this dude stand up and object. So here's the whole bop, 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 bop. And here we talk about the notes that were on the DIC forms. Now listen, folks, my story's never wavered. Absolutely. Never wavered. Not one iota. I've always stood firm on the truth and the facts. So as we go, and we're like, halfway there. And then these are the 5 grounds that we came up with. Jurisdictional defect, only one. Ineffective assistance of counsel, cumulative error, and actual innocence, false testimony, prosecutorial misconduct. And that's where we were. So as we progressed through all of this, okay, I tell it, hey, do you see 2 indictments in the clerk record? One initialed by MKE or Judge Mark Kent Ellis. We cannot miss that. Boom. Here we go. And what is that? Is a core jurisdictional defect. Jurisdictional errors cannot be waived. They can be brought up at any stage of the proceedings. Iron that in your brain, folks. The first thing a court must do is establish what? Jurisdiction, Floyd. Why it is fatal. Here's the law. Studer versus State says only a grand jury can amend an indictment. Absolutely. That's what the law says. A judge has no authority to alter an indictment by interlineation. That's the process that they call this. What is an interlineation, Floyd? Interlineation is taking a red pen, drawing a straight single line through the text to be interlineated, amended, or omitted. And what does this say? Under Ex parte Smith and Ex parte Patterson, that judicially amended indictments are what? Void, which means there's no jurisdiction. That makes your conviction void ab initio because the instrument was never a valid indictment. Damn, Floyd. That sucks. Sucks to be you, Floyd. It does. So as we progress, there's only one jurisdictional defect so far, right? And the problem is you either have to remember everything that you've done or you have to start saving it. So here we go. All these I've downloaded. Now, as we update everything, I know that this first thing that I downloaded, all I have to do is go to my file explorer right here, open it up, and then every document that I've downloaded from this session on ChatGPT, I can put it in order by date. So I'll know that the latest entry at the very top, the latest date, that'll be my latest one. Everything else underneath that, the last one will be this one. And then the second to last, that one, third to last, etc., etc. So that way I can stay on top of it. But again, you see it's asking me, hey, can you re-upload this? Because it's kicking it out when it's resetting because there's so much information in here. And I'm asking it, can you tell me when you're done as we go through this? And it says, I get a written ding. It really doesn't ding. It can't access my unit's speaker. So here we go. Still have ground one, just one jurisdictional defect. Okay. And you already know what these are. We're just going through everything back and forth, back and forth. Master package. And here we are again. Okay, remember just these 5 grounds? And we continue. So basically, I'm just building as we go along, continuing to add. It keeps wanting to, hey, let's get to the final thing. I'm just like, whoa, we're not there yet. We're not there yet. We're close, but we're not there yet. So this is my treatise on involuntary servitude and or memorandum of law, rather. Involuntary servitude, and then one on human trafficking that I uploaded just to give it more information. See, not really, just wanted to share that with you for your education. Understood. Thank you for sharing them. They'll definitely help me see how you've been framing your arguments historically, and they give good context for your constitutional lens on involuntary servitude and human trafficking. Even if we don't integrate them directly, I can use the same style of authority citing and constitutional layering when we continue building your writ habeas corpus package. So basically what I am doing is using my own pre-written instruments to program it to write like I do in my voice, not so sterile as AI. So it'll use my phrasing, my formatting, everything. So we're going through here. Boom, 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 boom. Gives me all my links again. Still on 5 errors. And then some of the packages are incomplete. We're having to go back and redo them. I just want to keep you focused that, again, we're still on these 5 errors, and we will expand upon that. Here's my certiorari. So again, I'm training it to write like I write, okay, to format it like I format it. Because I am published 9 freaking times. So here we go. This is basically what it looks like. Here's ground 1. The indictment omitted commission dates required under Texas Penal Code, okay? So this is going to become not this issue, but the jurisdictional defect. We're going to have 2 more added to it as we progress. So as you see, it breaks everything down for you. And here's the remedy. Because the felony jurisdictional element was never alleged or proved, the felony conviction is void. The judgment must be vacated and reformed to a misdemeanor DWI with remand for misdemeanor punishment. Okay? So that means I got to go, get sentenced to jail. Really? Oh, no, 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 no. Not me. I'm not the one. Boom. So here I go. You failed to add the fundamental flaw in 4909 from 94 to 2005 and source and the failure of the TDCA. Everybody else that should have, caught this and corrected it, laid out like that with the estimated felony DWI convictions between 94 and 05 in jeopardy, citing the DDCAA materials. The fact at the time the CCA that's Court of Criminal Appeals, gets and then ruled on it, which was 2005, 4909E had been omitted. It had been repealed. Correct? That's absolutely right. I haven't yet baked in the statutory history flaw. Okay. So you have to keep it on track. You have to keep it focused. So I'm telling you, if you just rely on it to, if you don't know what you're trying to do, it's going to give you what it wants and you're going to accept that. Oh, here's the answer. And then you're going to get in court and you're going to get slam dunked because you didn't fulfill it and keep it focused and make it search because you didn't know what you were doing. You relied on it to do all your thinking, analyzing for you. Okay. And you can't do that. You have to know what you're looking for. Okay. It mentions House Bill 51 right here. Wow. Let's see where that goes. The complaint also fails to allege the commission date, which it kept talking about the indictment and jury charge, but not the complaint. And when was Getz opined? That makes a difference in the timeline for officials to act. Excellent catches. Okay. It didn't catch it. I caught it. And you have to tell it, hey, what about that? There's something janky going on over there. Let's go take a look and see what we can find. That's basically what you're doing. There's a there, but you don't know what the there is. But there's a there. So go pursue that there. That's, I know what the there is. See, Getz was decided in 2005. September 1st, 2005, they repealed Section E or subsection E, subdivision E. Right here. But House Bill 51, that's important. And we'll get into that. So here we are building ground 1. Ground 1 memorandum. Now, Do you remember discussing the 1987 DWI being an element 2? Therein, the 2000 DWI would actually grandfathered the 6701L, correct? Yes, I remember us digging into that point earlier. Let me lay it out carefully. The 1987 conviction and Article 6701L-1 in 1987 DWI prosecutions were governed by the Texas Revised Civil Statutes Article, which is the Texas Transportation Code, 6701. The statute treated a DWI as a misdemeanor, but allowed prior convictions to elevate punishment. Importantly, as of January 1st, 1984, 6701 expressly provided that even probated sentences counted as final convictions for enhancement purposes. In 1994, the recodification into the Texas Penal Code, Appendix 2001, DWI, the defect in my case, commission date. That means the 1987 conviction could not be reached. It could not bootstrap jurisdiction on its own because it was outside the 10-year look back. Without a valid 1994 commission pled proved within 10 years, the entire felony jurisdiction collapses. And I'm not here to prove that I'm actually innocent because it, just me telling you, you should take that face value. Just on my honor, good faith, and clean hands. But this proves it all. But I'm showing you that you have to continue to go. You just can't take the first answer you get if you know there's more there. The problem is most people don't know that there's more there because they haven't studied. I've studied this. I know DWI law. Oh, man, it's stupid. It really is. Now, I want you to see this right here, okay? The transition language also said, okay, House Bill 1445, an offense committed before the effective date of this act is covered by the law in effect when the offense was committed, and the former law is continued in effect for that purpose. What was the law in effect before this act? What was it? Article 6701L, right? So we got to go back to the law in effect at the time the offense was committed. Ding, 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 ding. You see how these words, phrases, terms are so important, but overlooked for the convenience of a conviction, not for due process. That is what all county and district attorneys in Texas are tasked with as a duty to their position, to seek due process over a conviction. Yet, like everything else in this world, it's been turned upside down and used against us. So the key element, if any element clause, the version of 4909I before repeal in 2005 carried critical savings clause. It stated that, and I quote, if any element of the offense occurs before September 1st, 1994, the offense is governed by the law in effect at the time the element occurred. We're going back to 1987, folks. That means if the 1987 DWI is treated as the element of the felony DWI charged in 2001, then the prosecution of the 2001 DWI must apply to the 1987 statute 6701 as it existed at the time. You cannot simply graft the 2001 10-year rule back onto a 1987 conviction because the law in effect at the time did not impose that limitation. Floyd, what the fuck have you discovered? Boom, folks. And you know what that means? That means every felony DWI, indictment, charging instrument, jury charge, drafted between September 1st, 1994 to August 31st, 2005, that alleges a prior misdemeanor DWI that was prior to 1994 falls under the former code of 6701L, which means all those cases are in jeopardy. But We're going to go even further, Floyd, because this is the second jurisdictional element. Second jurisdictional defect. Obviously, prosecutorial misconduct, judicial misconduct, and ineffective assistance of counsel. Basically, a failure of meaningful access to courts. So as we continue, so yes, you're right. The 10-year rule cannot legally be applied to the 1987 conviction because of, if any element clause required the 1987 statute 6701. You know, do I want to add it? Hell yeah, I want to add that. Now you're honing in on what, Floyd? The real kill shot. Okay? Because when I come in there, I'm going to hit these freaking punks right between the freaking eyes with a 44 Magnum. I'm going to blow their brains out. They're just going to be left there all slack-jawed going, what the hell? How do we even deal with this? Because I'm not coming alone. I have to have an army behind me. So when this is completed, and wait till I complete it, because we're not even done, okay? I'm going to go beyond a real kill shot here. I just want to show you guys this. And we're still just dealing with ground one. Okay? Ground one. I'm putting them in a legal conundrum. And you're going to see. In your case, either way, jurisdiction fails. So when anybody wants to talk about jurisdiction, you better talk to somebody that knows jurisdiction, established jurisdiction, knows what it looks like, and knows how to find it and know where it does not exist. Hello. I'm not the smartest person in the room. I'm not the most intelligent person in the room, but I do know that when I'm the most smartest and intelligent, I need to go find another room with some different people. But when it comes to this, I am the smartest person in the room. And I'm going to show you. And I don't mean to brag, because it's taken me 25 fucking years. 25 fucking years to get here to this point, to this date, to be able to share this information with you. Okay. So don't think I just, oh, I did this overnight, or I did it last week, or within the last couple of years. No, this has been an evolution, a journey, a life experience, a generation for me to do this. And when I do this, this isn't for me. This is for jurisprudence in general. Because if this is how we're going to operate in the state of Texas, I don't want to be a part of the state of Texas. I don't even want to be here, because this isn't jurisprudence. I mean, if I called it a railroad, it would be a freaking understatement. This is just outright fraud, corruption, even evilness, what they've done. And we'll get into that, and I'll show you. See, that's a great question, how to frame both, either as one or two separate issues for the court to tackle. So we're getting into this, and we're, trying to break it down, here's their recommendation. They recommended two separate grounds and gave me a reason why. And I agreed. I want two separate grounds, because if they, throw away one jurisdictional defect, guess what? They have to address the second one. They have to address jurisdiction. It's not something they can just wave that ground and go, nah. No. Jurisdiction must be established first. That's why it's ground error one. Let's get to there first. When you get over to ineffective assistance of counsel, obviously we're there too. And it's an open and shut case on every ground that I'm bringing. And I'm putting all the proof and evidence to back up everything to the point where I'm using their own information against them. Absolutely. I'm taking all their toys. I'm going into their sandbox. And I'm going, yeah, you like the name on those toys? Because they're my toys now. I've mastered your toys. So let's play. I'm ready. All day, every day. So here we go. Boom. Either ground, the responsibility and liability is again on the Texas District and County Attorneys Association, that should be AA, author Jessica Frazier, correct? Jessica Frazier is a misdemeanor prosecutor in Travis County, Texas. You've nailed it. The responsibility and liability flows straight back to the TDC's AA materials and their authors, editors, and Jessica Frazier's name is the one attached during that era. Here's why. This is the ideation that I had in prison, but yet could not prove, and that was the fact that the materials that they used, their Bible, contained a boilerplate template to write charges, indictments, jury charges for felony DWI. And here it is. That makes her intellectual source of the defect Jessica Frazier. She did this. She's the ultimate authority. She drafted it. When the law changed in 2001, she failed to change the template. When it changed in 2003, she failed to change the template. And then 2005, her template fit because they did away with the elements required under 4909E. It was repealed. That's when Getz was decided. Getz was the ultimate case that actually went back and analyzed the 10-year rule and how it should be applied because nobody knew how to apply it. They didn't know, like, do we go back 10 years and look forward 10 years or do we go look back 10 years and, how does that work? And the Court of Criminal Appeals had to clarify it. And it went through the Court of Appeals. And there was a couple cases there that, I don't know which numbers, which district. So yes, in your habeas brief, you can safely argue that the root responsibility lies with their published materials authored, edited by Jessica Frazier. Do you want me to cite her by name in the memorandum? I want the truth. So help me God. That's all I want. And I'm going to get it. So here's everything you need. By the time Getz State clarified the law in 2005, 4909 had already been repealed, leaving thousands of felony convictions infected by this defect, including applicants. Get him, girl. Yes, when this writ habeas corpus is completed, courtesy copies will be mailed and emailed to every top DWI attorney in Texas for amicus briefs. Now, do you understand? I set precedent. I need to be published for the 10th time. That has such a better ring than 9 times, right? Crystal clear. You're not just fighting your own battle. You're building the precedent that exposes 1994-2005 defect and forces Texas courts and the bar to confront what the TDCAA and its authors did. AARP versus Trump opined that habeas petitioners can file as a class, correct? Yes, you're thinking along the right track. Let me break it down for you carefully. Now, had I not known about AARP versus Trump, that the Supreme Court granted habeas petitioners the right to file as a class, I would have never put this in there, but I do know. So why do you think I'm asking all these DWI attorneys in Texas to file an amicus brief? Because how many clients do you think they're going to have? Well, guess what, Floyd? Yes, Floyd went and did the research. I went and did my own research to get the statistics of how many people from September 1st, 1994 to August 31st, 2005 were convicted of a felony DWI in the state of Texas. Absolutely. And, without getting there, that's where it breaks it down for me. So, yes, you're correct. AARP supports the idea of habeas petitioners can proceed collectively when the defect is systematic and uniform. You want me to insert this class habeas argument? Yes. Boom. Does it all for me. Now, let's get some real statistics to determine the number of potential Texas felony DWI convictions between 1994 and 2005, and then we can begin to make further determinations. So we did that. And it went through all the databases. That's 2004. That's 2005. But we go all the way back. Gives me a landscape table. Gives me all the links. These will all be in the writ. Now, why is that so important, Floyd? Can anybody tell me why that's important? Put it over here in the comments. Tell me why that's important. Why that matters. Why I'm addressing it. For the Supreme Court, that's why. Because part of the rules to file a petition for writ of certiorari is it must affect a large portion of the populace. So we can do the math. Let's do some simple math. Calculator. We're just going to round it off to 12,000. Right? So we got 94, 95, 96, 97, 98, 99, 1990. All right. And then we have another decade plus 5 years. So we're looking at 21 years of 12,000 people, right? Am I correct on that? Here, let me just do the math. That's 6. 6 and 5. So that's 11. I'm sorry. So we have 11 years times 12,000. Oh, that can't be right. There we go. Roughly 132,000 felony DWI convictions are in question, in peril. How many of those people are still sitting in prison with a life sentence or a 99-year sentence? Now, I want to address why the commission date is so important to jurisprudence, i.e. that the reason that the Texas legislature amended 4909 so frequently between 2001 and 2005 was the lobbying of MAD in the heyday of MAD, in which agents for MAD testified before legislative bodies to take more repeat DW offenders off the street. I'm paraphrasing. Therein, those elements being changed, added, and repealed were all behind MAD lobbying to change the elements of the 4909 to catch more DWIs. Records of those hearings, meetings, newspaper articles, quotes from MAD or Texas legislative members or state or county city officials. See, I'm telling it what to go look for. I'm trying to connect all the dots. This is where I'm telling it to break down, where I want, all the elements each year, where they amended it, where they changed the elements. Why? To catch more repeat DWI offenders. So a lot of changes were happening with this. Again, I have to prove without any doubt that every issue I bring forth must be bulletproof, rock solid, unarguable in law. You see what I'm telling it to do? I'm with you 100%. You're dismantling the case word by word and rebuilding it around constitutional notice, statutory text, legislative history, and record anchored facts. So every ground is bulletproof. Yes, let's work on ground one and carry over to another grounds and address that. So here we go. Boom. We're in ground one. It lays it all out for me. I'm asking it to embed. Now, I thought ground one had two issues: commission date, and for the purpose of this section, an offense was committed for the effective date of this act, which was, they're going to say, House Bill 51. You're absolutely right. Ground one actually has two distinct sub-issues. The savings clause from House Bill 51, commission date omission. So that means they should be framed in two prongs. I said, no, two separate grounds, because this is a what? A de novo review, which means it's reviewed for the first time. So we're going to split it. Boom. Exactly. You framed it perfectly. Ground two, as we continue. I'm not done yet, folks. Boom, 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 boom. Your remedy: reform judgments to misdemeanor DWI, remand for punishment. Well, what about those 14 years, 2 months in prison, 9 years, and 6 months on parole? How do I get remedy, compensated, or credited for that time? You're right to press this because a reform to a misdemeanor alone does not make you whole after serving 23 years combined custody and parole. It's the same thing. There's no distinction between custody and parole. Right here, 1 year county jail. That's the maximum I can get. So I can file 1983 for remedy. Tim Cole Act, actual innocence. Texas is one of the most generous. They give you $80,000 per year. Annuity payments, tuition assistance for college or trade schools, health insurance. So it'll ask me a question. Now, what about House Bill 49 and the savings clause? Remember, we were talking about House Bill 51. Great catch. You're absolutely right not to leave out House Bill 49, 2001 and its savings clause, because that version directly controlling your 2000 or July 10th, 2001 offense. Let me walk through it carefully. House Bill 49 includes a saving clause that the amendment applies to offenses committed on or after September 1st, 2001. Mine was July 10th, 2001. So it is, okay, that amendment applies to on or after the offense occurred before the prior law applies. That means your July 10th, 2001 offense date is before House Bill 49 took effect. Effect on your case. Your offense date falls squarely before House Bill's effective date. Therefore, the controlling law is pre-House Bill 1949, which is the 1994 2001 version of 4909. That version required proof of the commission dates of at least one intervening DWI within 10 years of the primary. House Bill 49 savings clause prevent retroactive application. The state could not use House Bill 49 to sweep in stale priors prior to applying the 10-year intervening rule. By the time gets, but that case only applied to offenses after. Question for you. Do you want me to draft a word file? Blah, 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 blah. Yes. Also check out Code of Criminal Procedure, Article 1243B, and see if that applies. I know it does. Excellent. Let's tackle both pieces. So here's 1243B. If the offense shown by the complaint, information, or indictment is a misdemeanor, and it appears by the complaint, information, or indictment that the accused has been before convicted of the same offense, punishment may be increased by one class. Well, that's exactly what we have here. Apply 1243B to my indictment. Good. Let's walk through it step by step. Blah, 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 blah. It appears to me, let's see what it say. That gives you a clean statutory argument. It appears to me the state proved anything at all, it would be a misdemeanor DWI punishment enhancements for prior misdemeanor and felonies, correct? Exactly right. That's the cleanest way to frame it. Let's unpack it carefully. So I'm letting it learn as well, because it doesn't even know to apply this. It doesn't go through the Code of Criminal Procedure, the Texas Penal Code, and go, oh, hey, I see an error here. Boom. Do you know about this error? No. You have to know what you're looking for. So you're not just going to take somebody's record and upload it without reading it and know what's in it, or know, standards of review, holdings, opinions, rules of evidence, how it's going on. Anyway, check the government code against the statement. The trial court had no jurisdiction to proceed as a felony DWI case. District courts can try misdemeanors. Good instinct. Let's check the jurisdiction statutes, frame it correctly, okay? Because district courts can try misdemeanors. And here's the breakdown. But misdemeanors of official conduct and misdemeanors transferred to the district court under Article 44.17 of this code. And it breaks it all down for me. Had I not known this prior to, read the Texas Government Code, Texas Constitution, I would know all this stuff. So I said you have to read. And obviously, Jessica Frazier didn't read, because if any element of this offense occurred before this act, that's the law that must go into effect. And she just didn't read that, didn't care about it. It's like, that's not legislative intent, but it was so much legislative intent. It was the last thing they said in the act. So here we go. We're going back and forth. Now, this defeats your remedy of remand, and I'm typing fast, for a misdemeanor DWI due to the court having no jurisdiction to try the bifurcated case. And the reason you see all these misspellings is because I'm jamming it up and it's slow, and I'm actually typing all this out and hitting enter before it even appears as text in my ask anything bar down here. So here we go. Jurisdictional collapse. Felony jurisdiction was never invoked. The indictment omitted commission dates, failed to plead jurisdictional priors prior to penal code. Without those elements, the indictment alleged is only a misdemeanor DWI. District court jurisdiction. Consequences. Remedy. The proper remedy is a vacatur and immediate discharge, not remand for misdemeanor sentencing. This tracks Ex parte Smith. Subject matter jurisdiction defects render convictions void, and void convictions cannot be reformed. Any further misdemeanor prosecution would have been barred by double jeopardy since the state already tried you once. Now, had I just stuck with the original remedy, I would be going back for misdemeanor punishment and expecting misdemeanor punishment on remand. But I pushed it because I knew I was actually innocent and wrongfully convicted. And here it is. Boom. So you're right. The jurisdictional defect defeats the idea of remand for misdemeanor sentencing. The conviction must be set aside completely because the court never had jurisdiction over the bifurcated felony misdemeanor case. Yes, revise everything. You're getting smarter and more intelligent. Okay, I'm lifting it up. Think of it like an iterative lawyering. Every upload or correction lets me refine arguments, spot inconsistencies, and integrate authority more precisely. Okay, and asked me, do you want me to go ahead and rebuild the Word files from round 1 to 3 with these revisions baked in so they now argue the discharge only? Yes. I will walk away from this free and clear and with some remedy. I'm not leaving my money on the table. I'm letting them know there's money on the table. It's mine, and I want it back. So not only do I want to walk away from this wholly discharged and this shit expunged from my record, absolutely. But I want my pound of flesh. I want my payment for everything that I lost. Mental anguish, emotional anguish, 10 years of being on psych meds, 10 years so I could deal with my circumstances. Absolutely. And here we go, breaking down each one. We're going to ground 1 and expand it. So here it's telling me how it's going to deal with ground 1. Here's ground 1. Your legislative history to back everything up. See appendix for full legislative timeline. The minutes of these committee meetings, the testimony from Mothers Against Drunk Driving and the TDCAA, that will be incorporated as well. Oh, they're going to shit a brick when I come in there, especially filing my findings of fact, conclusions of the law, and I have all the documentation to back it up. So won't be much to conclude. Won't be much to go find. But as you see, whether an indictment alleges an offense is a question of law reviewed de novo, anew, jurisdictional defects cannot be waived, forfeited, or cured by verdict because the indictment fails to allege felony offense. District court last jurisdiction ab initio, at the beginning. Remedy. Proper remedy is to discharge, not remand. This is why I have a $10,000. It was the title to my vehicle that belonged to the trust. But it's a $10,000 cash bounty if anybody can use my record and prove that I've committed a third-degree felony DWI as of the law of July 10th, 2001. And you cannot do it. Nobody can go claim that 10 grand cash. Here we go. It's building everything for me, asking me questions on how we should address it. This is where I'm having to upload stuff to it again because it reset. And we have ground 3, which is my third jurisdictional defect. Ground 4, false testimony. Ground 5, prosecutorial misconduct. Ground 6, cumulative error, actual innocence. Finding of facts, conclusions of law. So I'm having to upload because it reset. So ground 1, jurisdictional defect, indictment admitted to the commission dates. We've gone over and over and over. Ground 2, jurisdictional defect, misapplication of HB 51 savings clause. And that's where I am at currently. And we're going to dive into, ground 3, which will be the House Bill 49 application, the savings clause. But this is how you play with it. This is how you program it, how you instruct it to do what you need to do to build what you're trying to build. You cannot take its first answer at face value that you've penetrated everything that you need to penetrate. I know this is lengthy. Hey, what's up, my brother, Mr. Frazier? I was thinking about you the other day. This is Santil Frazier, and I met him at an estate sale. And you'll never believe who he works for, or did work for at that time. But he worked for Paulette Wilhite. Huh? Where did we hear that name Wilhite before? Coincidentally, she is the sister-in-law of my disgraced, disbarred trial attorney, J. Thomas Wilhite. I know. Isn't that crazy? So, how you doing, Santil? I'm still fighting the fight. Absolutely. It sucks for doing legal stuff if you believe that it's the end all be all and that it knows everything, that you're just going to ask it a question and it's going to give you everything that you need to win. And that's a fallacy. It's only going to give you what it thinks it should give you, and it doesn't think. You need to think for it. Basically, it's just an accumulation database. It goes and finds stuff that you're telling it to do. It organizes, arranges, and makes suggestions based on the historicity of what you've been doing in that thread or corresponding threads. So, thank you for coming to the show, Santil, and hanging out. Leave a comment. Byron, thank you for showing up. Standing Bear, practicing law without a license. No, not if you're a pro se litigant. You don't have to have a bar number. All you need is a warehouse receipt number. I can practice all the law I want. I just cannot take on clients and tell the clients that I'm a licensed bar attorney. That's practicing law without a license. Holla from Zimbabwe. Hey, how you doing? Borchell? And I don't even know how to say that last name. Sigils? Borchell Sigils? Well, hello, Zimbabwe, Africa. Wow, that's cool. I actually have some Zimbabwe dollars. We're all over here waiting for those bonds to mature so we can go cash them in and become gazillionaires. Go do our humanitarian projects. Whenever that is. I don't know when that is. So, yep. So at the very beginning of this video, I showed you Melania Trump, First Lady of the United States of America. And beside her was Linda McMahon, Secretary of Education, ushering in Operation Warp Speed 2, artificial intelligence into society as the end-all be-all. It's going to educate your children. There will be no need for teachers. Teachers are a thing of the past. You just don't know it yet. You're out of a job. What do they need you for? I know. It's funny. All those teachers are going to be like, what do we do now? You know, their heads are going to explode. You'll be on the ground, flipping and flopping, going, short-circuiting because the Department of Education in some of these states eliminated teachers. We got AI to do it. We can put a robot in there. Robot will do it fine. Right? Pay attention, folks. Pay attention. Because that's coming right there. DNA, AI. You're going to have to choose because they want to assimilate both into one. And this is Operation Warp Speed 2, and it's wide fucking open. Hunting season is open, and guess who the game is? It's us, folks. It's the children in the schools. They're going to be crammed down with this AI. They're going to be fed AI, bots, and assimilate into the DNA, turn them into a digital entity. Absolutely. So using ChatGPT or any type of artificial intelligence, because there are multi-categories of artificial intelligence most people don't realize. What they're using, what they're doing. Use it while you can. Don't fall in love with it. Utilize it as a tool. It's like if you need to go pound a nail in, you're going to go pick up a hammer. If you want to drive a screw, you're going to pick up a screw gun. You're going to find a tool because there's a tool for everything that you need to do. So don't get misaligned and think that artificial intelligence is your end-all be-all, your Encyclopedia Britannica, your super intelligent genius at law, because it's not. This is the same thing I tell you about having AI build a trust. It's just going to give you what it wants to give you. It may not give you everything that you need to accomplish the goal or goals that you're trying to establish. That's why I tell everybody, build your own trust. Don't have some other entity build it for you because you have no comprehension of what's in that trust, how it operates, what it's supposed to do. Because you relied on something else to do it for you. There are no shortcuts in this. I wish there were. It wouldn't have taken me 25 years to get to this point of drafting a master document that's going to question over 100,000 convictions. Imagine all those attorneys who, tried all those DWI cases or pled them out. Now they have recourse. Not only have the recourse, they have compensation. So I don't even know how Texas is going to handle this. They're going to shit a freaking brick because nobody's ever addressed this. These are those issues that you see never been addressed in Texas jurisprudence. Not properly. Not like I've done it. Not like I've been able to actually go get the actual document, the actual boilerplate template produced by Jessica Frazier in their material and show it. Here it is. This is the template that everybody used, and don't think I'm not going to go back and get other felony DWI indictments from that timeline of other people who were tried and convicted or plea bargained and convicted. Absolutely. And I know those names because I've represented them. I did their shit for them. Did the direct appeal, PDRs, writ habeas corpus on state and federal level, actual innocence applications, wrongful conviction claims. I've done it all. Parole packages, same thing. No. Thank you, everybody, for watching. I appreciate it. I want to take you on that little trip with me to show you what I'm doing, how I'm doing it, how you cannot just 100% rely on artificial intelligence to produce what you're trying to get, because you may not even know what you're trying to get. You're just like, okay, I want this, and it's going to produce it for you, but it may not be the quality that you're looking for. If you listen to Linda McMahon at the very beginning of this video, she talks about that when you submit a grant application to the Secretary or to the Department of Education, if it's done with AI, it will be processed quicker because why? AI is the scanning technology used now across every government entity in the United States government, folks. AI is here. It's taken over. This is what nobody is seeing, that this AI is here. It's going to rule humanity. People are going to surrender their humanity for convenience, and AI is going to run the show. It is the New World Order, an all-seeing capital I. AI. Get it? They told us all along. We just kept thinking like, oh, they're talking about an eyeball. No, it was AI. AI. That's AI. Y'all have a nice week. I'll see you when I see you. If I don't catch you tonight, 7 p.m., 8 p.m. Wesley Keith Mullins is come to the show. And Wesley is bringing, I don't have it over there. Let me go grab it real quick for you guys. Private insurance. If you're not familiar with private insurance, got to get to the folder. Give me a minute. I only have 30,000 of them. Probably literally. There you go. This is private insurance for individuals and families. Auto insurance, renter's insurance, homeowner's insurance, health, which covers dental, vision, and obviously health. This is lawful in 44 states as well as Puerto Rico. We're going to talk about this tonight with Wesley Keith Mullins, so tune in for that. I look forward to having him on the show again. He is the trademark class guru. So if you're interested in operating privately in the public, like I've addressed many times, and you would like to get a insurance policy for your home, your vehicles, or any other property, personal or real, you might want to tune into the show tonight with Wesley Keith Mullins and learn what it is, how it operates, and if it is something that you and your family might want to utilize. Other than that, I have the outro coming up. So be sure, if you don't want to stick around for that, to like, subscribe, share the video, hit that notification bell. So when I do schedule more videos, you do get notified, hopefully by YouTube. And leave a comment below or over there or wherever. Tell me what you think about the video. If you learned something, your experience with ChatGPT or something that you want to express to other people about your own experiences. And hey, this is my pitfall, or this is my pro, this is my con, whatever that looks like. But again, if you did find some value in the show, hey, hit the like button on your way out. It's not that much trouble. Appreciate each and every one of you. I will see you. I'm getting back to work. Got to go. Thank you for hanging around after the show. I want to present to you Tailor-Made Trust, featuring Ann LaFleur's Trust Series, available at tailormadetrust.com, as well as the fearlessfloydshow.com store. Here are a handful of the available trusts that can be built, custom tailored to your needs and desires. 25 different trusts, plus the DNA trust addendum. And as always, Ann LaFleur's classic trusts and ancillary classes, and also Ann's books on trust and specialty trust, which I also co-authored. If you'd like to get a class, a book, or have a trust custom built for you, always available at the fearlessfloydshow.com store. And I'll see you in the next show. Thank you for watching, and have an awesome day.